University. To the continuation of the previous session, today we are going to discuss about the principle of subrogation. First, you have to know the meaning of the term subrogation. The subrogation means the restitution or transfer of the rights of an assured in favor of the insurer against the third party of any damages caused by him in place of the assured after the insurer has indemnified him for the loss. The principle of subrogation is invoked when a third party is responsible for the loss. Okay. The principle of subrogation is invoked when a third party is responsible for the loss. Okay. The principle of subrogation is applicable to fire and marine insurance policies. So this concept is applicable for both fire and marine insurance policies. It is to be noted that on the happening of the event for which the asset has been insured and after the damage has been caused, the insured can sue the party who has caused the damage to claim compensation for the loss. Alternatively, the insured can seek compensation from the insurance company. So ultimately, when the loss will happen, so the insurer will seek the financial aid or compensation from the insurance company. Okay. In case the insured opts for the later course, he loses the rights to sue the party who has caused the damage and seek further compensation from him. In accordance with the principle of subrogation, the insurance company acquires the right of the insured to sue the third party to compensate for his negligence and loss inflicted upon with its indemnifies the insured the losses suffered by him. Okay. In case the insured opts for the later courses, he loses the rights to sue the party who has caused the damage and seek further compensation from him. Okay. In accordance with the principles of subrogation, the insurance company acquires the right of the insured to sue the third party to compensate for his negligence and loss inflicted upon when it indemnifies the insured the losses suffered by him. Therefore, if the assured recovers the full extent of the loss from the insurance company, then the insurance company gets the rights and remedies of the assured and can proceed against the third party for the recovery of compensation. So in case the insured also receives the compensation from the party in respect of the same loss, then he must pay that amount to the insurance company. Okay. Now we'll see one example. You see, Mr. X was on his way to office in his car when it was hit from behind by a lorry and the lorry driver was drunk. Okay. Here, X can claim compensation from the insurance company. The insurer in turn can sue the lorry owner Y for the damages. So here the X will receive the entire compensation from the lorry owner, is called Mr. Y. Okay. Here X will have no right of action against Y if he receives compensation for the loss from the insurer. Okay. Now you see the one more example. Mr. A insures his house with an insurance company. The house is burnt by fire and A recovers the loss from the insurance company. A subsequently brings an action against his neighbor who was responsible for the fire and recovers damages from the neighbor. Here the insurance company is entitled to the amount which A has received from his neighbor. So A must pay the amount to the insurance company. Okay. And the last one is the insurer of an importer of electrical goods receives a claim in respect of a fault the insurer of an import of electrical goods received a claim in respect of a fault toasted. The insurer pays the claim but takes over the insured rights to claim back against the manufacturer. The insurance company can proceed with this claim in the insured name. Okay. Thus, it can be seen that subrogation rights apply only where loss is a legal ability under the policy. That is, where policy is covered, existed, and the claims are paid. However, the policy condition customarily provide for the subrogation rights before the claim payment. So recovery from the third party can be made only if the claim is paid. It is to be noted that the principle of subrogation is a corollary of the principle of indemnity and is applicable when the damage has been caused due to the negligence or high handedness of another party. The principle of indemnity seeks to make good the financial loss suffered by the insured by the insurer. Thus, after having been compensated for the loss, the insured is restored to the same financial position as he was before the incident. In case he is allowed to sue the damaging party against, he stands to make a profit from the loss, which is inconsistent with the principle of indemnity. Now, we will discuss importance of the principle of subrogation. So, what are the importance of the principle of subrogation? The principle of subrogation serves to achieve the following objectives. Number one, it prevents the insured from profiting from the damage. Okay, it prevents the insured from profiting from the damage, that is, obtaining compensation twice for the same loss. Number two, it enforces the rule of law that the guilty is brought back and made to pay for the loss. Third one is, it helps the insurer to partially or fully recover the amount paid for the loss. Okay, it helps the insurer to partially or fully recover the amount paid for the loss. The last importance is, it helps to lower the insurance rates with reimbursement from the concerned third party. The insurance company's losses are substantially scaled down, the benefit of which in turn is passed on to the final policyholder by way of reduction in premium. Whenever the insurance company indemnifies the insured to the extent of the full value of the insurance policy, that is, when the asset is completely damaged, the insurer takes possession of the damaged asset to realize the salvage value. Here, the salvage value will play a vital role for claiming. It has to be noted that if the value of compensation recovered by the insurance company from the responsible third party is more than the amount indemnified to the insured, the insurer has to return the excess amount to the insured after deducting the expenses incurred in recovering the money, such as legal charges. So, after deduct all the expenses, the balance amount to be paid to the policy holder. In a case where the insured himself takes action against the negligent party, the insured is not liable to pay any compensation. if the insured chooses to relieve the negligent party from his liability for the loss that may happen when the concerned person is a close relation of the insured. The insurer is not liable for compensation as his right to sue the negligent party is lost. Now we are going to discuss about the importance of the principle of subrogation. Now we are going to discuss about the limitations of the doctrine of subrogation. This doctrine is not applicable to life insurance policies, and therefore the insurer has no right of action against third parties responsible for the death. The second one is the doctrine becomes operative only after the insured has been indemnified. There is no relation between the indemnity provided for and the exercise of subrogation. The insurer may not be able to recover exactly the same amount by exercising the right of subrogation against the third party. The last one is subrogation cannot be exercised where the assured is not in a position to take action against the damaged party. The next topic is principle of contribution. First, you have to know the meaning of the term contribution. The Federation of the Indian Institute of Bombay has defined the principle of contribution as the right of an insurer who has paid for a loss under a policy to recover a proportionate amount from the other insurers who are liable for the loss. Thus, contribution is the right of an insurer to call upon others similarly, but not necessarily equally liable to the same insured to share the cost of an indemnity payment. This principle of contribution enables the total claim to be shared in fair way. The doctrine of contribution operates as a corollary of the doctrine of indemnity and hence is applicable to general insurance. The principle of contribution should be property worded in the contract. The general wording is, if at the time of any loss, damage or liability arising under this policy, there shall be any other insurance, whether affected by the insured or any other person, covering the same property or liability or any part thereof, the company shall not be liable for more than its rateable portion of loss or damage. Thus, as per the doctrine of contribution, the indemnity provided for the loss occurring on the asset, which is insured with several insured, has to be proportionately shared among them according to the rateable proportion of the loss. The amount of total compensation or indemnity provided to the insured by all the insurers should not exceed the amount of loss. In case one insurer indemnifies the insured in full, the concerned insurance company can claim the share of compensation from other insurance companies. The requisite to invoke the doctrine of contribution: number one, the insured asset or person subject to matter of insurance in case of hospitalization insurance must be common to all the policies. Number two, the risk insured against must be common to all the policies. Third one, the insured owner of the asset must be the same person. The last one is all the policies must be in force during the occurrence of loss. Example, where there are two insurers covering the asset equally, in case of loss, each has to contribute half of the compensation. So in this case, you have to know how can they claim the compensation from the insurance company. You see, Mr. A insured his house against fire with X for rupees 50,000 and with Y for rupees 75,000. So he has taken insurance against property from two persons. One is X, another one is Y. Fire broke out in the building and a loss of rupees 40,000 occurs. So A may file a suit against both the insurers or against only one. But here he has to claim insurance from either X or Y or from both. So, but here he has to use the following formula. The liability of each insurer is determined by applying the following formula. The formula is the sum insured with an insurer, the particular insurer, either X or Y, divided by the total sum insured with all insurers. Here you have to take both the insured value from A as well as X and Y. 50,000 plus 75,000, 1,25,000. Multiply by the actual loss. Okay, the formula is the sum insured with an insurer divided by the total sum insured with all insurers into actual loss. Okay. So liability of X that equal to 50,000 divided by 1,25,000. 1,25,000 is 50,000 plus 75,000. Right? So multiply by rupees 40,000. So 50 divided by 1,25,000 into 40,000, that equal to 16,000. This is a loss will be claimed from Mr. X. Then liability of Y is 75,000 divided by 1,25,000 into 40, that equal to 25,000, 24,000. Okay. It has to be noted that a life insurance is a contingent contract, and such the principle of contribution will not apply to life policies, because the principle of contribution is applicable only for general insurance like fire, marine and burglary and theft, etc. So, but it is not applicable to life policies, life insurance policies. Okay. If the same life has been insured more than once, all the amount will become payable in full. The following conditions must be satisfied for the applicability of the principle of contribution. Number 1, the same subject matter is insured with more than one insurer. Number 2, the policies must cover the same peril. Number 3, the assured must be the same person in all the policies. Fourth one, all the policies must be in force at the time of loss. The last one is each insurer has to pay to the insured his share of loss only. So these are all the conditions must be satisfied for the applicability of the principle of contribution. Now we are going to discuss about the principle of proximate cause. The proximate cause is a key principle of insurance and is concerned with how the loss or damage actually occurred and whether it is indeed as a result of an insured peril and is payable under the affected policy issued by the concerned insurer. Okay, so cause is a key principle of insurance and is concerned with how the loss or damage actually occurred and whether it is indeed as a result of an insured peril and is payable under the affected policy issued by the concerned insurer. Definition. The cause proxima is necessary for a valid contract of insurance. It has been defined as the active efficient cause that sets in motion a train of events which brings about a result without the intervention of any force, started and working actively from a new and independent source. It is not the latest but the direct dominant and operative and efficient cause that must be regarded as proximate. When an insurance policy is bought, it is issued with respect to some peril, which may result in loss to the policyholder. No policy covers all type of risk. The insurance company is liable to indemnify only against the insured perils. The term proximate cause literally means the nearest cause or direct cause. So, the term proximity cause literally means the nearest cause or direct cause. Okay. In insurance parlance, it relates to the immediate cause of the mishap which resulted in the loss. In general insurance, there are numerous policies relating to vehicle insurance, property insurance, fire insurance, burglary insurance, etc. Each policy offers protection from the risk that are mentioned in the policy. If a person has bought fire insurance for his house, the protection will be from the loss caused by fire, which may have resulted from the source mentioned in the policy. In case the fire occurs from any source other than that mentioned in the policy, the insurer is not liable to compensate the insured. For example, if the person is insured to be protected against fire occurring due to electric short circuit and the fire occurs due to leakage of LPG cylinder, then the insurance company is not liable to pay for the loss, because they have a person has taken policy against the loss due to the electric short circuit only, not the loss due to the leakage of LPG and etc. Okay. In this case, only if the fire were caused by short circuit would be the loss be covered. Okay. The second one is sugar was insured against the danger of seawater. Rats made a hole which caused the seawater to damage the goods. Okay. Though rats were originally responsible for this damage, so the immediate cause of damage, proximate cause of damage was seawater, a peril insured against. Okay. Hence the insured was held entitled to damages.